Hello learners, welcome back to your education channel Learn and Educate. Let us continue with our law series Code of Civil Procedure 1908 under which section 61 under the heading attachment. Section 61 states about partial exemption of agricultural producer. The state government may, by general or a special order published in the official gazette, declare that such portions of the agricultural producer or of any class of agricultural producer as may be appear to the central government to be necessary for the purpose of providing until the next harvest for due cultivation of the land and for the support of the judgment debtor and his family shall in the case of all agriculturists or of any class of agriculturists to be exempted from the liability to attachment or sale in execution of a decree as per section 61. Partial exemption will be given with respect to agricultural producer in general or special order which is published in the official gazette to declare the portion of the agricultural producer or any class of agricultural producer as per the state government necessary for the purpose of providing until the next harvest until the next harvesting and until the due cultivation is done of the land the support it is a support to the judgment debtor and his family that exemption will be given with respect to agricultural producer of one particular type or such portion of agricultural producer to provide support to the judgment debtor and his family in the case of all agriculturists or any class of agriculturist shall be exempted from the liability to attachment or sale in execution of decree, that is for the under the order of any court for the execution of a decree or from the liability to the attachment they will be exempted. What the agriculture producer, a certain part of agriculture producer. Section 62, seizure of property in dwelling house. Subsection 1, no person executing any process under this code directing or authorizing seizure of immovable property shall enter in a dwelling house after sunset and sunrise. That is, for the purpose of seizure of a property in the dwelling house, no person executing the decree will not be allowed. Executing the process of another code of civil procedure 1908 will not be allowed to move enter the dwelling houses after the sunset and before the sunrise. Subsection 2 states about no the outer door of the dwelling house shall be broken upon unless such dwelling house is in the occupancy or access to, but the person executing in the house believes that that any access to the dwelling house and he has reasons to believe for any such execution. Then another subsection where the judgment debtor refuses or it is having a gained access to the dwelling house, then the person executing or any such person or for any process has gained any access to the dwelling house, he may broke upon the door of any room in which he has reasons to believe that such property that no outer door of the dwelling house shall be broken, but unless such dwelling house is in the occupancy of the judgment debtor and he refuses in any way prevents access to, but any person executing it has reasons that in to any dwelling house he may broke the door of any room but not the outer door of the dwelling house. Outer door of the dwelling house will not be broken, but if any room shall be broken, if he has reasons that such in such property in that particular room, the judgment debtor he refuses and prevents access. Subsection 3 of section 62, where the room in a dwelling house is in the actual, where a particular room in a dwelling house is in the actual occupancy of a woman who according to the customs or conduct does not appear in the public, and the person executing the person shall give notice to such woman that she is at liberty to withdraw the same, and after giving a reasonable time of the withdrawal to that particular facility, and he may enter such room for the purpose of seizure of the property, and the judgment debtor will be arrested accordingly. Under this subsection 3, a woman, according to the law of the according as per the customs of the country, does not appear in the public, and the person executing the process shall give a notice to such a person, shall give notice to the woman that she is at liberty to withdraw. And second, it can be given facility of seizing the property. At the same time, precaution, consistency, and the provisions to prevent this claims demand shall be removed. Therefore, one has to understand the section subsection 2 deals with that no outer room, no outer door of the dwelling house shall be broken, but with respect to particular any inner door can be broken for the purpose of detention of the judgment debtor. And as per subsection 3, the woman shall be at liberty and the reasonable facility for withdrawal, then the executing person executing by the process may enter such room for the purpose of seizure of the property, using at the same time every precaution consistent with the provisions to prevent this to prevent its removal. Subsection 3, property attached in execution of decree of several court. Section 63 states about where the property not in the custody of the court will be attached. The property which is not in the custody of the court is under attachment in execution of decree of more than one court, then the court which shall receive or realize this property and shall determine any claim thereto. Any objection to the attachment of it shall by the court of the highest grade, or whereunder there is a difference in the grade between such courts, then the courts whose decree the property shall be finally attached. Then there is no difference in the grade, then such court, the court under whose decree the property was first attached, will have the property, will have the final claim of the property, which says that where there is no difference, where there is no difference between the grades of the court, then the court under whose decree the property was first attached will have the right to receive realize the property and have determined any claim according to that. As per subsection 2, nothing in this section shall be deemed to do invalidate any proceedings are taken by any court. Nothing in this section shall be deemed to invalidate any proceedings taken by any court executing such one of such deeds. For nothing in this subsection shall be deemed to invalidate any proceedings taken by the court excluding executing one of such decrees. Explanation is that for the purpose of subsection, proceedings taken by court does not include an order allowing to a decree holder who has purchased the property at a sale held in execution of a decree set off to the extent of the purchase price payable by him. Section 54, private alienation of property after attachment to be void. The under it subsection 1, where an attachment has been made, then any property which is transferred or delivered of delivery of the property attached or of any interest on it, and, and any payment to the judgment debtor of any debt, dividend or other monies contrary to such attachment shall be void as against all the claims enforceable under the attachment. Subsection 1 states that the private alienation of the property after the attachment to be void when an attachment has been made, any private transfer or delivery of the property attached or any interest therein, and any payment made payment of the judgment debtor of any debt, dividend or other monies contrary to such attachment shall be void as against all claims enforceable under the attachment. It means say that when a property has been attached by the court, by the order of the court, by the decree, by judgment, then the judgment debtor he cannot sell the property privately to another person. He cannot lend it or he cannot give it with the interest, with the title of the property with respect to any payment which was due against the judgment debtor to that person or any dividend or money which is contrary to the attachment with respect to the same attachment where they when the property to subject to the execution of a court when the property has been mentioned in the decree that it would be executed, then that property against that property any private alienation is not allowed. Subsection 2 states about the nothing in this section shall apply to any private transfer or delivery of the property attached to or any interest on it made in accordance made in persons of the contractor for such transfer or delivery entered into and registered before the attachment. Explanation states for the purpose of this section, claims enforceable under an attachment include claims for the rate able distribution of the assets. Subsection section 61 or subsections 2 states that nothing in this section shall apply to any private transfer or delivery of the property attached to or any interest upon it made in pursuance of any contract for such transfer or delivery entered into and registered before the attachment. What has happened then before the declaration of the results, before the declaration of judgment, before the passing of order by the court, any interest or delivery of the property has been made, entered into, registered before the attachment will be transferred, and nothing and the provisions of section 61 shall apply, because section 61 states that after the attachment has been made, private alienation of the property is not allowed, it will be void, but anything done before registered before the attachment, it will be valid. Explanation is for the purpose of this section. Claims enforceable under an attachment includes claims for the rateable distribution of the goods. For the purpose of this claim enforceable under an attachment includes claims for rateable distribution of goods. Rateable distribution of goods means as per anything appropriate by the court determined ranking, it would be for the purpose of distribution of